right, good evening. It's Monday, January the 17th, 2022. This is a workshop for elected officials training. So let's call the meeting to order, and let's do a roll call.
Jeff Arnold.
Here.
Wendy O'Nucky.
Here.
Joe Reeser. Here. Joe Reeser.
Here.
Steve Schlack. George Sleeper.
Here.
Letitia Wilkins.
Here.
Scott Smith.
Here.
Make a motion to excuse Steve Slack.
Second.
Motion is second to excuse Councilmember Schlock. All in favor say aye.
Aye.
Aye. Opposed, no. He's excused. And that just takes us right on to the workshop training. So I'm going to turn it over to Chris Johnson. Good evening, Chris, and thank you for being here with us.
Happy to be here. Just a little bit about me before we get started. I've been practicing municipal law for over 40 years now, in all sorts of various capacities, including defending about every kind of municipal government or state government that you can think of. So it's been an interesting ride. In addition to that, I'm a recovering politician. I served on our school board for 12 years, and then I was mayor of my community for another 28. So
Wow.
I've actually been on your side of the table and know that it isn't easy to do all the things I'm going to tell you what you should be doing. A little bit about the MML to start with. We have a great organization that's here to assist you. We do a lot of lobbying. We do a lot of working on your behalf. We have a blog that we call Inside 208, and it gives you the latest of what's going on, especially in Lansing and Washington, things that are going to impact you right now today or tomorrow or the day after that. So you can sign up for that blog and get on it real easily. It's written by our state and federal affairs folks, and I think it's very interesting for you to do. We also are involved with a special finance initiative called Save My City. It's kind of interesting. The state has withdrawn about $8.6 billion from local units of government in revenue sharing alone. And I think that your share that you lost between 2002 and 2017 is over $2 million. You had $2 million extra dollars in your fund balance, things would be a lot easier for you. And what I think is kind of interesting is a state legislator that might come up to you and say, hey, you don't even know how to budget, you don't know how to handle your finances. If you kind of took that kind of whack out of their budget, they'd be having a different attitude toward it. We have an inquiry service, which I think is really good. You can contact us, and we've got notes for you, so you don't have to copy all this down. But if you've got a question of a general nature, let us know. I'm not your attorney. You have a city attorney, so if you need to rely on legal advice that way, you have to ask your city attorney. I do have to warn you about that. But our inquiry service handles a lot of different areas. We have a lot of one-pager pluses on our website, so there's topics that are already organized on the website, and you can find a lot of information that way. We also have a couple of primers that are available through the league. If you'd like to get a copy of those, just ask and we'll send them out. We have sample documents, sample ordinances, so maybe your city attorney hasn't dealt with that particular issue before. We have a lot of resources available to them as well. So let's start about a little bit of an introduction to local government. What are its origins, its powers and functions, as well as what are the roles of council, the mayor, and the manager. One of the things that I have to warn you about right now, right off the bat, is it's constantly evolving. We're subject to all of the changes that the legislature might throw at us, or the appellate courts may throw at us, or the Supreme Court might throw at us. We're granted existence from the state constitution, so we have to follow the Constitution as well as the ordinances and statutes that the state of Michigan prescribes. The state in 1963 in that Constitution actually gave us some cities and villages home rule power, and that's a little bit different than anything we had prior to that. I know the 63 Constitution is getting old. might need revision someday, but it really is a good section to allow us to do what we need to do on a local basis. So again, I want to point out that we have legislation that's going to affect cities and villages, townships, all county government, as well as the court opinions. Lastly, as you know, public opinion has a lot to do with how you'll be doing your job. And if you don't think that doesn't happen, if this room were filled up with another 50 people, you knew something happened that maybe you are going to find out about if you don't already know. So what kind of governments do we have in this state? First, we have counties. There are 83 counties in the state, and I don't know, for bonus points, if you ever have been to all 83 counties, I have been. I'm one of the few people I know, though, that have been to all 83 counties and never ran for a statewide office. We have cities. We have a lot of cities in Michigan. We have 280 of them. Most are home rule. Fourth class and fifth class have been folded into home rule cities. And we have one special charter city in the state, the city of Mackinac Island. So they're special because they have a special charter. We have villages in the state of Michigan, general law and home rule villages both, and there are 253 of those. And finally, we have townships, both general law townships and charter townships. We have 1,240 townships in this state. So if you think we have a lot of government in the state of Michigan, you'd be correct, because we do. Of those 240 townships, 138 of them are charter townships. Then we have special units, purpose units, school districts, for example, intermediate school districts, various library districts are out there. So there's just another whole plethora of government out there that doesn't even fall into these categories of the 1,700, units of local government. As I mentioned before, Michigan gives us a little bit of a special status of being a home rule city and the right to actually have our own place in the Constitution. And for us, a charter is pretty much equal to our Constitution. It's the local unit of government versus the state or federal government. Cities and home rule villages must include a few items in their charter that are like the elections, how you elect the public officials, tax rate, the fact that you have to follow the Open Meetings Act, and to protect peace, health, and safety. It may include a lot of other things like water, sewer, streets, special assessments. And there's at least one item that's in there for you may not have a millage rate greater than 20 mils. That's also an item that's in that. Ordinances basically equal statutes. So it's the local law versus state law. One thing about an ordinance, though, if you want to give it the force of law, you need to adopt the ordinance. You can't just pass a resolution. So if you want to enforce it in a court or have criminal penalties attached if you violate it, you have to go the ordinance route. In South Haven, you have a pretty clear document in your charter as to who does what in all of the city functions. Chapters 4, 5, 6, 7, and 8 all get there. And what I tell every newly elected official or every public official that I know of, go back to your founding document. In your case, it's the charter, and it explains what the rules are and what the roles are. And they're unique in every community. How they do it in Dearborn Heights is different than how they do it here. And it's going to be that way. So learn what your rules are and what your responsibilities are. You also have to remember what your limitations are. You are not responsible for what goes on in other local units of government. You sure should try to cooperate with them, but you must point out to your public sometimes, hey, we don't do that, the county does, or the state does, or whoever might be in charge of that. And you should direct them to those public officials. Knowing your role is really important, and understanding that role really goes to how successful I think your community will be. Again, I'll point out, it's all spelled out in your charter. But your city council here is responsible as the policymaking body of the government. You're responsible for long-term and short-term goals. You're responsible for adopting a budget and a capital improvement plan. These are big items. These are really important concepts. So if you have a big goal, and let's just pick one, we're going to fix the damn roads. If you only put $1.98 in the budget to fix the damn roads, you're only going to do about this much, and it's not going to be accomplished. So line up your goals and objectives to your budget plan and your capital outlay plan. Putting that all together makes for a good situation where then you can hold the administration responsible for meeting the goal or not meeting the goal. But you can't say, hey, you didn't fix the roads if you didn't pass any money in the budget to actually accomplish that. Remember that you can only act as a body, as the city council together. And you act through your resolutions, you act through your ordinances, you adopt the budget. All these things you do as a body, not as individual members of the city council. And I always advocate that council should and can adopt rules for procedure. How you want to do business is up to you as to how that goes. And reasonable rules and responsibilities are right there in your rules. Now, again, I really want to point this out. You can only act as a council. You can't say be an individual member and go tell the director of DPW, hey, that pothole needs to be fixed today because my neighbors are having a party here. That's not how it's done. You have to act together as a council. And it's really important to recognize you need a majority of the council to do that. So, you know, you can have agreements or disagreements among yourselves where you vote the other way, but what the city does is what the majority of the council wants to do. So there's some special responsibilities for the mayor and or presiding officer if we're talking about, say, the Planning Commission. You have to acknowledge members who wish to speak. You have to be courteous to the members of the council and to the public. You have to fairly enforce the rules of council and fairly enforce public comment sections of the meeting. By that I mean you can't sit there and say, I'm only going to call on Dave because I like Dave and I'm not going to pay attention to what Mary wants to do. I mean, that's not the role of the presiding officer. The presiding officer has to be fair. And in many respects, whether you know it or not, and I know it from sitting in that chair, how you do your job as a mayor or the presiding officer is how a citizen out there is going to view the city. If you're kind and courteous, chances are you'll have a more kind and courteous audience. If you're being nasty to them, guess what's going to happen? They're going to give it right back to you. Another thing that I think is really important is public comment is public comment. It's not the Prime Minister's answer section in the House of Commons, as Boris Johnson is finding out right now. You're not under an obligation to answer questions, and sometimes a question might come up, hey, when does that program start? Oh, it starts on May the 1st. Real easy to handle. If somebody gets up and says, you know, I want to know on the 5th line item of the budget, da-da-da-da-da, and whoever came up with that, and if you don't know, you can defer that question and we'll get back to you on that. So resist debate. You know, there's nothing that's going to be accomplished by debating your positions with the audience. Explaining your position to the audience is different than getting involved with a debate. In fact, I had a council member that I had to restrain one time because he got offended by a comment. Just settle down. So sometimes the most appropriate answer is thank you for your comment, and your comment is noted. Now, the city manager form of government developed in the early 20th century as part of an effort to reform government. Quite frankly, you had a situation in most communities that the person who got the most votes got the position. Well, that doesn't necessarily mean they know anything about a wastewater treatment plant. Might not mean they know anything about elections other than getting more votes than the other person. However, they were trying to bring a little bit more professionalism into city government. And out of the 280 cities that we have in the state of Michigan, 234 of them have managers. So it's really the form of government that most Michigan cities have. City manager is responsible for implementing your goals and objectives and is responsible to keep you as a council aware of what's going on. It's responsible for the day-to-day operations of the city. And I was very thankful that when somebody would call up and say, hey, my garbage didn't get picked up today, I could say, here's the phone number of the city manager, and please let her know about what's going on. And if you want to compare it at all to a corporate structure, the manager is the CEO of the organization. So one of the things you do need to think about is the kinds and types of communication that you want to have with the manager. What kind of information do you really need? Do you need to know what the critical infrastructure is? Yeah. The budget priorities? Certainly. Where you buy the pencils? Probably not so much. You know, just make sure that what you need is something that all of you agree on, at least as a majority. And obviously, if you ask a question, you have information or need information, and if it's important to you, it's probably important to the whole group. One of the things that I noticed, I had one council member that was really bad at this. He was always trying to play gotcha. And he ended up looking pretty foolish because almost every time he asked a question about a gotcha type thing, it was always in the packet and he hadn't read it. So, you know, he ended up looking more foolish than anybody else. But what happens when you do that to people, you play gotcha all the time, you're starting to destroy your relationship with other council members, and you're starting to destroy your relationship with the staff members. Once you lose that trust, it'll be very hard to get it back. So as I mentioned, you're acting as a body, and it means that you need to win over your fellow council members to accomplish your goals. And you don't do that by insulting each other. I guess I go back to that awful Saturday night live sketch at the very beginning where Dan Aykroyd turns around to Jane and he says, "Jane, you ignorant slut." Well, guess what? You do something like that to a fellow council member, you will never get them to go along with what you're looking for. You just don't insult people. There's no benefit to it. And if you give respect, you'll get respect. It's a two-way street. You can't have it both ways. So, as we look for ethics, I think it's a very important part. It's the appearance of what you're doing. How you conduct your business in an ethical fashion is probably one of the things that, in a smaller community like yours, it makes a huge difference. The Institute for Local Government sets 4 specific tenets for ethical consideration. And the first is to not benefit financially from your position. You know, we have all sorts of problems in this state with people, you know, taking money under the table. There's a lot of unfortunate situations where we have council members and even mayors in this community or in this state go to jail because they had their hand out and were illegally taking bribes. It's really sad, but it's really true. Also, along the same line is do not receive special benefits by virtue of your position. Let me give you a quick example. I live on Main Street in my community. It turns out that the fire station is literally 1 block away from my house. So where does the snowplow go first? Plows out the police station and the fire station. That's the first thing that they do. Well, that's because the mayor lives on Main Street. No, you got to make sure they understand it's because the fire station is on Main Street. And besides, my garage actually faced West Street, which is one of the last streets to actually get plowed because I'm on a corner. But you have to make sure people understand that you're not walking into a restaurant and getting free food because they're worried about whether you're going to like them or not. That's not your role. And you got to understand that you shouldn't benefit specially just by having your position. Don't be secretive in your decision-making. And as we talk about the Open Meetings Act a little bit later on, you'll see where that comes from. And don't let favoritism or bias cloud your decision-making. That is really important because you need to hear the other side every once in a while. I can still remember a citizen coming up in the middle of a meeting and saying, hey, did you ever consider doing it this way? And we all kind of looked at each other and go, no, we hadn't. Guess who was on the committee starting right that meeting? Brought a great idea to the city, just got up and, no, we hadn't really thought of that. And instead of just pushing back at him, and, you know, maybe that was a good idea. We just hadn't thought of it yet. There are a bunch of good resources for you, and I listed them in the materials I gave you for being mindful of ethical conduct. But I think Potter Stewart probably said it best. What you have the right to do does not equal what is right to do. He also knew that he couldn't define pornography, but he knew what it was. So he wrote that in a famous opinion as well. Also, we also have now social media, and it's really kind of taken on a new life of its own. And it's a good way to communicate to the public, but I think you need to take care if you have your own personal Facebook or some other social media page to make it clear that this is my idea. It isn't the city's idea unless it's been voted on by the whole council and is the formal position of the city. So don't represent your own personal views as that of the city. And as we discussed a couple of times, you're a member of the council, you're not the council. I strongly recommend a social media policy that makes kind of some of these rules a little bit clearer. It'll explain when you're walking over the line. There's a lot of them out there, and we have a few available through the MML as well. And sometimes people, I don't know whether your community uses individual council members as liaisons to various commissions or boards. A lot of them do. Your role isn't, as a liaison, anything more than transmitting information back and forth between the city council and the various board or commission that you're talking about. So remember that is, you're not there to interpret, you're there to inform both ways. So now we're going to get into a little bit of the meat of Michigan's sunshine laws, and these are kind of interesting and different sections. The Freedom of Information Act is the first one, and quite frankly, it all started out because of Watergate in 1974, where the president was keeping lists in the Oval Office of different people that were on his enemies list and things like that that nobody knew about. And as a result of that, the Michigan legislature actually enacted two things, the Freedom of Information Act and the Open Meetings Act in 1976. And they were effective January 1 of 1977. I was on the school board at that time, and I can assure you that it radically changed the way business was done in our community. The Policy Act is real simple. It's actually stated right there in the legislation, and it says that all persons, except for those that are incarcerated, are entitled to full and complete information regarding the affairs of government. And the whole purpose of that, as courts have held over and over and over, that the people shall be informed about what's going on in government so that they can participate. So what does the city need to do? It has to provide a public record. And it's described in the statute as a writing that is prepared, owned, used, or in the possession of a public body from the time it's created. So that's a real important concept as well. And what is a writing? It's also got, you know, the standard handwriting, typewriting. Remember, we're talking about 1976 when this was written. Words, letters, pictures, symbols, paper tapes, magnetic tapes. They were thinking of the tape that ultimately brought down President Nixon. And then they threw this in: other means of recording or retaining meaningful content. That's an important new thing that they just thought of at the very end of that sentence. And the reason why we have that is this woman here. It's a picture of Rosemary Woods, if you don't know. She was the president's secretary and was responsible for that 17.5-minute gap in the Watergate tapes as she was transcribing it and leaning over to answer the phone, and kept her, who knows whether that happened or not, but that's the way that the administration tried to do it. So we ended up with that every other means of recording or retaining information as being a part of that. So while it doesn't seem obvious at the moment, and certainly wasn't thought of in 1976, paper, emails, texts, voicemails, or even entries on a mobile data terminal, those are in your police cars. So as they're transmitting data to each other and it's not going over the radio, it still could be FOIA'd at a later point in time unless there's an exception that goes with it. So your responsibility under FOIA is to appoint a FOIA coordinator, and that's the person that's going to actually handle it. I have a 4-hour course, just beginners for FOIA coordinators. It's that complicated. So your FOIA coordinator will be doing all the heavy lifting here. You need to provide and make sure the city has reasonable access and reasonable protection to all your documents. These are really tight timelines, by the way. You have 5 business days to respond. 5. That's 1 week. Or you can also get 1 10-day extension. And I've had judges lecture me from the bench. Can't you count, Mr. Johnson? 1, 2, 3. You know, there's nothing to say to that if you're 6 days out, or it's, you know, 17 days out after you requested an extension. There just isn't an excuse. So I do tell my clients not to appoint a procrastinator as your FOIA coordinator, because that's going to lead to a disaster. You want to get it on the coordinator's desk as soon as they can and get it off the coordinator's desk as soon as that person can.
Hey, Chris.
Yes.
That 5 days to respond, that would be to respond, but not necessarily complete the request, right?
That's correct. You may grant the request and you're still assembling a mountain of documents, so that's acceptable. You don't have to create a document that doesn't exist, and that's kind of one of those bones of contention that you get into a lot with various requesters. We don't have that. Oh, you have to have that. Well, if you don't have it, you don't have it. So you may say, oh, that's a county record, go down the street and go see it there. Now, some of the records that you'll find that are exempt under FOIA are bids until the bid is selected. That would be nice if you knew what the guy down the street was bidding on the project. Test questions and answers, tentative bargaining agreements until it's ratified, or some of the information that's protected under the Crime Victims Act, like the photos of the bloody murder, that sort of thing, that often protected under the Victim Rights Act. Some other common exceptions that might apply to your situation are attorney-client privilege documents. For example, if the city attorney sends you some correspondence specifically outlining an opinion and the facts that they're based on, that document is considered confidential. Personal information is sometimes exempted under the Freedom of Information Act, but there's a couple of caveats to that, in that the information truly must be personal, reveal embarrassing items about a person's private life. Although there is one case out there, ESPN versus MSU, where they were looking for some information on some college athletes, and the court actually granted that one. But I think it was the nature of the fact that the persons were kind of visible public figures. And it also has to be that the release does not help the public understand how the government operates. So, for example, your banking information, if that's in a person's personnel record because you're sending the money directly to the employee's bank account, that's personal, has nothing to do with the fact that anybody's doing it, and it would lead to them potentially getting, hacked into their banking system. Exemptions for invasion of privacy. Just as I mentioned before, generally personnel records are not exempt. Certain information contained in the personnel record is exempt: Social Security number, cell phone information, banking information, health information. But generally those aren't exempt, except for when we have law enforcement records. Law enforcement personnel records are exempt. The reason should be obvious. Bad guys like to do bad things to law enforcement officers, and you like to protect them. If you have a situation where you have an ongoing criminal investigation and release of the police report might actually set the investigation backwards, that's also exempt. Operational plans of a law enforcement department are exempt. How will you respond to a bank robbery in progress? Bad guys would like to know that. It would make robbing the bank a lot easier if they did that. And finally, personnel records for the officer, with some exceptions, is generally protected. So, this stuff was science fiction in 1976. It just plain didn't exist. All the computers in front of you. My cell phone here has more computing power than the lunar excursion module that landed on the moon. It was just total science fiction in 1976. So you have to remember that FOIA was passed in 1976, and there was no such thing then as email, text messaging, social media, and all those things. It just didn't exist. But because we get another means of recording or storing information as part of the definition of the Freedom of Information Act under what a record is, it is still subject to a Freedom of Information Act. There's a very significant case out there called Howell Education Association versus the Howell Board of Education. And I would spend a good 20 minutes talking to a FOIA coordinator about that case and all the way that it got to the court. However, there are two major concepts in that case that you need to be aware of. And first is, there's a brand new concept that the court created called purely personal information. And that was situations where a teacher might be sending an email to their spouse and saying, hey, would you pick up the bread and milk because I'm going to be late, I'm in a meeting, or, sending an email to another teacher, say, hey, would you like to go out for dinner tonight? It has nothing to do with the operation of the school, nothing to do with anything involving the government. What it does have is purely personal information. However, this is the most significant thing. The content of the message is more important than where the message is stored. So, if you have an email account through the city, I strongly advise you to do all of your communications regarding city matters on that email account. That will make it very easy for the FOIA coordinator to get all of the documents together in one place and never even have to bother you, to say, do you have anything more? If the only record is on your own personal cell phone or your own personal computer, computer. You may have a state circuit court judge say, bring your hard drive in and we're going to clone it to find out if there's any of these messages on your computer. I've actually had a number of cases where I defended where a circuit court judge in fact said, bring in that hard drive. No, it's my computer. It's all mine. It's private. No, it's not private. If you're dealing with city business on your own personal device, you're risking having that cloned and, have somebody review it for, that specific information. So things have changed since 1976, but the statute really hasn't. We have a lot of resource materials on FOIA, and these are just a few of them, including a great section in the Michigan Municipal Law section from the continuing, or ICL, which is Continuing Legal Education for Lawyers. And that section was recently updated as recently as 2018. They're great reads. They're legalistic and somewhat boring, but they're things that you'd need to know about. So I'm trying to go really fast because I know you have another meeting. And I'm going faster than I normally would. So if you do have questions, we'll take them at the end. Open Meetings Act. And again, remember how we got there. It was Watergate specifically. So I want to start off with the actual language of the statute because sometimes people miss this going in. Any state or local legislative body, including a board, commission, committee, or subcommittee, is required to follow the Open Meetings Act. When you're empowered by either the local ordinance or state law, you're subject to the Open Meetings Act. So all these people that spent all sorts of time trying to argue that, well, we didn't have a quorum here, we just had 3 of the 7 of us, or we just had 2 of the 5 of us, or whatever. There's still a subcommittee. And they're contained within the definition of the statute since 1976. And you had all these attorneys trying to figure out ways to get around it. Well, you can't. There just aren't any ways around it. There are certain sections, and we're going to go over those in detail, about why certain meetings can be closed. But you can't just wiggle your way out of it by saying, oh, we didn't have a quorum. That's not going to fly. And every circuit court judge I've seen won't let it fly. Basic intent, again, is to let all Michigan citizens know about what's going on in their government by conducting almost all of your business in public. And I got to admit, the judicial view is very consistent since they've started in on these cases. And here's one from 1998. And look at the way that the judge is pounding his table as he's, we're not going to use strained legalisms or evasions. You can see his frustration and the intent of that in defining what the Open Meetings Act. And it's consistent since 1978 when these cases started coming down. Been very consistent. So, unless there's a statutory exemption, all meetings of the public shall be open. All decisions of the public body have to be made in an open meeting. So you can discuss some things in a closed session, but when you come to make a decision, you have to do it at the public meeting. And finally, unless an exemption occurs, all deliberations of the public body must take place in an open meeting. So the Act applies if you're talking about a public body, and certainly the City Council is, and all your various boards and commissions are, your Planning Commission, ZBA, and things like that, meets with a quorum present or a constructive quorum. And we'll get into a case a little bit later on that. Convene for the purpose of deliberating or rendering a decision. So deliberating is not only debating between A and B, it might be just to eliminate C, D, E, and F. as you're narrowing things down to a decision. And something by which a vote of the public body is necessary to effectuate public policy. So you're thinking about the budget again. You're thinking about rules of the council, that sort of thing. And deliberation really has been defined as any discussion that leads toward a decision. Carefully considering your options. Everybody starts off with, throw all these things up on the wall, see which one sticks kind of thing. And interestingly enough, there's also a case out there recently in 2016 that said no actual deliberation is necessary. If the meeting was convened for the purpose of deliberating, they still got in trouble that way. So, as I was mentioning before, subquorums are committees. We had a really interesting case out of the University of Michigan where the University Council said if we put 3 of the regents in this room and 3 of the regents in this room and 3 of the regents in this room, and one regent went to all 3 and talked about what the other group, court said no. You might be the University of Michigan, but you're still subject to the Open Meetings Act. And figuring out all these intricate ways of avoiding the public isn't going to work in this situation. And it even goes toward a constructive quorum, even if there isn't an actual quorum. So we do have cases out there that way as well. So don't try and evade the Open Meetings Act. Almost invariably, you'll run into legal trouble. So what is required? First of all is notice. Within 10 days of your first meeting, either the first meeting of the calendar year or the fiscal year, your choice, you have to post your regular meeting schedule. And if you change that schedule, you must post the change within 3 days of making that change. My community, for example, we used to meet on the first and the third Mondays. Well, the first and third Mondays constantly run into holidays. So if we hadn't noticed it when we adopted our original list of meetings, we'd change it as soon as somebody noticed, oh, that one is Memorial Day, so we won't be having a meeting on Memorial Day. Regular or rescheduled regular meetings as well as special meetings need at least 18 hours notice. And please, please, please do not try and skimp out on that one. I had a judge, again, lecture me from the bench. Your client can't count 18 hours. It turned out to be 16 hours. And it was one of those mess-ups that's human error. Oh, I thought it was in time, but, then they listed the time at the meeting instead of the 8 o'clock usual time for the meeting. They're going to have the special meeting at 6 o'clock. So she posts a notice thinking it's an 8 o'clock when it was a 6 o'clock, and the circuit court judge hammered me. And you must keep minutes of all meetings. Now, this is a real interesting issue because minutes of meetings only need the date, the time, the place, the members that are present in absence, and any decisions that are made. Motion by Joe, supported by Dave, to do this. And that's a decision that has to go in the minutes. And who votes which way has to be in the minutes, too, if they're not unanimous. That's all that's required under the Open Meetings Act. There's a big difference between minutes of a meeting and a court transcript. The purpose of a court transcript is to write down every word that everybody says. Again, I'll go back to some personal experience I had. I was attending meetings of the city council before I became mayor. And they would spend 20 to 30 minutes arguing about the wording in the minutes because, council member so-and-so thought he should be quoted more than he was, and he didn't really say that. He said this, and he's trying to change what he'd actually said at the meeting. That's not how detailed your meeting minutes need to be. They need to say, council had a discussion. You might generally say they debated these couple of options and then they had a motion and then a support and it passed, or it didn't pass. So it's not a court transcript. Public comment's important in the Open Meetings Act. Citizens have the right to address the meeting, and the video or tape record it, and now come in with their cell phones and do it that way. They can do that. You can set reasonable rules on that, so you don't have to allow NBC News to come up and be within 3 inches of your face while you're talking. You know, you can say you set your cameras up there as a reasonable rule. I haven't seen any rules yet that turn out to be voided by the court as long as they were reasonable. And a person may only be removed from a public meeting if they're causing a breach of the peace at the meeting, that meeting. So Chris Johnson comes in and I'm being a total idiot. The police chief finally, escorts me out the door, and I want to come to the next meeting. You can't keep me from being there. I might be an idiot again. I might disrupt the meeting again, and I'll have to be escorted out the door again. But I might be good this time. I might have learned my lesson. Sometimes people learn, sometimes they don't. But you can't throw somebody out of the meeting prospectively. And I've even seen a few city attorneys try because, they have one citizen, and we all probably have that one citizen that wants to be known for whatever. And they tried to get a judge to say, this person can't go to any more meetings. I've never, in my 40-year career, seen a judge that will buy that. They just won't do it. If he's bad in the meeting, throw him out. If he's bad at the next meeting, throw him out. So, breach of the peace at the meeting. You have the ability to limit citizen comments to a certain portion of the agenda, and I've never really perused your agendas. You can do it at the beginning of the meeting. You can do it at the time when the agenda item comes up. You can do it at the end of the meeting. I'll give you some political advice here. If you do it at the end of the meeting after you've made all your decisions, you're going to have an angry public if they haven't gotten a chance to tell you what they think of before you make the decision. You can do it, but you may not survive your next election. I've seen elections lost on that very issue. You can restrict the amount of time an individual has, and I see you have a time card up here, so you probably do have to enforce that. You could be, anything that's reasonable. I've seen 2 minutes be reasonable. I've seen, an hour. But the problem is you cannot do the total amount of time. So if you have the 50 members of the audience and they all want to speak to you, you're going to be here for a long time, even at 5 minutes. Even at 2 minutes, you'd be here for a long time. However, there is a technique that I used, and I kind of recommend it. When you've heard the same thing happen from somebody's mouth for the third or fourth time, and it's basically everybody's getting up and almost reading the same speech to you, I'll usually say, okay, Mr. Smith, I've heard you say A, B, C, and D, and try and quote them as accurately as you can. Show that you're actively listening. Yeah, that's what I'm trying to tell you guys. Okay, so who in the audience here agrees with Mr. Smith that we should do A, B, C, and D? Raise your hand. You will be shocked at how many people will just raise their hand because they agree with Mr. Smith. But I was talking about being fair earlier. Okay, how many of you disagree with Mr. Smith? And raise your hand, and you'll get a smattering of hands that go up that way. You've just allowed those people in the audience to participate. They have told you what they think you should do. You're free to accept what they say or disregard what they say. That's your choice as a council. However, you've allowed them to participate. And the number of folks then that want to go up and say the same thing almost is eliminated. There's a few exceptions to that. And if they get their 5 minutes, they get their 5 minutes. But they haven't told you anything new. And they've already told you how many people in this crowd today think the same thing. So it's a good technique to use, it's something you can use. But you can't set a total amount of time to it. And I've seen certain litigations start because they didn't go through the whole 120 people that signed up to speak against whatever. Now, we're going to get into the closed sessions, calling it and closing it. First, there has to be a motion in the open meeting to go into closed session. And what you need to do is say the specific reason in the motion that you're going into closed session. We're going into closed session to talk about collective bargaining agreement with the police union, for example. And you need a majority vote to go in for discipline or personnel evaluation or for collective bargaining agreement. However, all the other 4 exceptions in the Open Meetings Act require at least a 2/3 roll call vote. I think it's a good idea to do a roll call vote anyway. It just gets you in that habit, and it makes sure that you don't mess up on one of those. It's really easy to just do them all by roll call. Now, I'm going to go in the order of the statute. These are not in the order of importance. I might reorder them, you might reorder them, but this is the way they go in the statute. So if a named person requests to consider dismissal, suspension, or discipline, or to hear complaints or charges brought against that individual, they have a right to go into closed session. As a practical matter, I advised all my clients when I was in private practice to request it in writing so that there's no question for the circuit court judge later. Hey, I've got this piece of paper. He signed it, you know. So then there's no question. But remember that that same individual has a right during the closed session to say, hey, wait a minute. I think this is now turning into a kangaroo court and I want it out in public. Stop the closed meeting and go out and finish the meeting in public. Might be embarrassing to that individual, but it's the individual's choice, not the public body's choice. Second reason is for strategy sessions or on negotiations for a collective bargaining agreement, if requested by either party. So maybe you want to do it in the open and the union doesn't want to do it in the open. So if the union requests a closed session, then you have to go into closed session to discuss that. I also, on this one, recommend that you do it fairly close in time to when you're going to be negotiating that contract, because you can strategize and build consensus among your counsel before you go into negotiation, but if your contract doesn't expire for another 5 years, unless you're trying to reopen the contract, chances are a circuit court judge is going to frown on that. Your third reason for going into a closed session is for the purchase or lease of real property. This one, again, should be obvious, and the reason is, as soon as an owner of property thinks that government wants to buy my property, the price triples. It just goes off the charts. Why? Because they're under the mistaken impression that government has more money than anybody else, and they should jack up the price accordingly. So keep all of your negotiations regarding a specific piece of property that might be at Main Street and Elm Street confidential until you're ready to, purchase the property or sign a lease. I would note, though, this is a one-way street. It's for the purchase of real estate or lease of real estate. It is not for the sale of real estate, and sometimes we have public officials that confuse that. Anything regarding the sale of public property has to be done at a public meeting. Fourth exception listed in the statute is to consult with your attorney regarding some specific litigation. And by this I mean a case of Smith versus the city of South Haven, where you actually have a plaintiff and you actually are part of the defense of that case. And that's only if it's detrimental to the public body's financial position. Just think about it. I actually was at a meeting. They couldn't get the 2/3 of the folks to agree to go into closed session. And what I was going to tell the client was, you really should settle this case because your police officer really did a number on this citizen and didn't have any legal basis to do so. Well, I was not going to say that in a public meeting, so they decided they wanted to do it in open session. They had my written opinion anyway, I just turned around and walked out the door because I knew that as soon as I said that in a public meeting, the price of the settlement would triple, quadruple, maybe even go off the charts. You know, something that could have been settled for $30,000 just became a $1 million issue. The fifth reason you can go into closed session is to consider the applications of appointment for a public office if the candidate requests confidentiality. Again, it should be obvious. We do have some communities out here that, you know, if you're even thinking of looking at another job, bettering your position, getting a higher amount of money, oh, you're fired. You know, so that happens in a number of communities. So they created this exception so that you would have a larger pool of applicants in the event that you need to hire someone. Again, the key here is if the applicant requests confidentiality. However, once you get to the point where you're interviewing for that position, if the public body actually interviews for that position, you have to conduct the actual interview in public. The contents of the application then get disclosed to the public. So you're going to interview A, B, and C for the position of whatever city attorney. That interview has to be conducted in public. And finally, there's an exception in here where the material that you're discussing falls under privacy exemption, for example, under FOIA. You're going to be discussing what your plans are to defend the bank situation because you had a bank robbery and you want to review with the police chief a new and revised methodology for handling bank robberies. You can go into closed session to discuss that because it's exempt under the Freedom of Information Act. Again, some examples are to review a written opinion of your city attorney, an appraisal for property. For example, you get your appraisal in for the property at Elm Street and Main Street, and you don't want that disclosed until you're finally getting to the point where you're purchasing the property. Or security plans, as I mentioned before. This is how we're going to defend the water plant. These are the security plans that we have there. Now, you do need to keep a separate set of minutes for the closed session. And again, I think it's really best to keep it as bare bones as possible. Date, time, place, members present, and we discussed the collective bargaining agreement. Thank you very much. And the meeting got over at whatever time. The clerk or designated secretary of the public body keeps those minutes. And those minutes may be disclosed only if ordered by a judge in a proceeding. So just because I was in closed session and I was getting my personnel evaluation and then I decided I want those minutes disclosed, you don't disclose that unless a judge orders you to produce those minutes. Again, you can meet in closed session to discuss the closed session minutes. If you do one of those epistle type sets of minutes, which again I don't recommend that you do, you can go into closed session to discuss the closed session minutes. And you may destroy those minutes 1 year and 1 day after they've been approved at your regular meeting. So if you had a closed session tonight and you adopt them, say, February 1st, they would be able to be destroyed 1 year and 1 day after February 1st. What happens in closed session should stay closed, kind of like what happens in Las Vegas should stay in Las Vegas. There's a reason for that. And the Attorney General had an opinion that said you risk criminal and civil penalties under the Open Meetings Act for disclosing the minutes of a meeting. There's a lot of municipal attorneys that argue that even the discussions that happen in closed session should stay there as well. The reason is obvious. If I'm discussing the purchase of property, again, at Main and Elm Street, and my buddy owns that property, and I let him know that the city's interested in it, guess what? You've really harmed the public by now having to pay a lot more for that property than you would have if you didn't disclose it to the property owner. And it could be a violation of your ethics ordinance if you have one, council rules or a code of conduct if you have them. Certainly a violation of Robert's Rules of Order if you've adopted those as part of your meeting procedures. Could be considered a violation of your oath of office and possibly a violation of the State Ethics Act. So again, the purpose of going into the closed session is stated right there in the body of the Open Meetings Act, and it should remain confidential. So here's a real problem, and the problem is technology has changed since 1976. And I kind of look at this particular photo as being this terrible wreck has happened, and all those people looking on the side are the state legislators that haven't taken any action about bringing the Open Meetings Act into 2022. Again, these things were science fiction in 1976. You didn't have to consider whether or not the technology that really helps us out in so many respects, makes our lives very easy in many respects, is the antithesis of the Open Meetings Act. So, can you do deliberations electronically? You've been trained in business pretty much that if the issue is important enough, you send an email out to everybody that's involved with the project and lay out your case. I think we should do X because of Y and Z and 1 and 2 and 3. And then everybody in the organization hits reply all. Hey, great idea. Boy, that's dumb. And this is the reason why it's dumb. And, you know, you get 30 different responses from all the people that you sent the email to. And that was the purpose of the reply all. Well, guess what? If you have a council member that comes up with a great idea and another council member starts responding with reply all, and another council member starts reply all, and on your council, if you have at least 4 of you do that, what have you done?
At a meeting.
You had a meeting. You did it electronically. You did it conveniently. You did it the way you've been taught in business. But you just violated the Open Meetings Act. And here's another big trap we have right now today that didn't exist. Social media. So you have a Facebook page, and you come up with some great idea, and you publish it on Facebook. And all your other council members are your friends and have friended your page. And then somebody else on the council says, hey, wait a minute, I don't like that idea. And then somebody else comes in and goes, no, that's a great idea. And then you get the, that back and forth going on social media. And while it might be a little more open than a closed email, you still got a problem. And what is the problem? You haven't followed any of the requirements of the Open Meetings Act, especially with respect to having notice, a chance to speak on the issue, and all sorts of interesting problems. And you've done it electronically, and you didn't necessarily even mean to violate the Open Meetings Act. But you have. So what happens when that happens? Well, they can invalidate your decision. Prosecutor can do it, or any other person, which includes media, by the way, can come in and file an action in circuit court to overturn your action. And while you do have the ability to redo it in a public meeting, there's still consequences for doing it wrong in the first place. And as I mentioned before, any public official who disseminates closed session minutes could be risking criminal prosecution or penalties. And that's the specific Attorney General opinion that I'm referring to. And here's a new one that you should be aware of. Unlike violations of the Freedom of Information Act, which are monetary penalties, an intentional violation of the Open Meetings Act could get you a criminal misdemeanor. The first offense is 90 days or $1,000, or the second or subsequent ones are a year in jail and $2,000. $2,000 isn't anything compared to a year in jail. but it's not funny anymore. So don't ever intentionally violate the Open Meetings Act. And kind of, you know, in that same vein, the Attorney General was asked about it at a recent news conference. And, you know, she basically promised, if somebody gives me a solid case, I'm going to go after them. And we've never had an Attorney General since 1976 ever say that publicly. You know, I don't think the AG really wants to prosecute people that make a mistake, but if it's intentional, she intends to go after you. Then we had COVID, which has brought a whole new situation to us. And the governor issued a number of executive orders allowing virtual meetings with a lot of requirements and stipulations. I don't know if you took advantage of those executive orders or the subsequent statute. But the Michigan Supreme Court issued some very important decisions on that matter, and they involved the Emergency Powers of the Governors Act, which had been adopted in 1946, and the Emergency Management Act of 1976. Court ruled that the Emergency Management Act required that the legislature agree with the governor's orders after 28 days in order to extend them. And if they didn't, those orders expire. They also ruled that the 1946 Act was unconstitutional because it gave the governor too many legislative powers. So basically, through the governor's ability to act out, and then they finally got together and passed some legislation. And they basically passed Public Act 228 of 2020, which allowed virtual meetings for any reason until March 31, and then gave 2 exemptions for health-related issues and locally declared emergencies up until the end of December of last year. Those have expired, as you well know. So now you have to do all your meetings in public. You can attend remotely, but you can't count toward a quorum and you can't vote or have that counted. Quite frankly, just personal Chris Johnson speaking to you is they haven't been to a hospital lately and seen how crowded it is to just get into the hospital. I've unfortunately had some personal experience trying to get a loved one into the hospital, 48 hours in the emergency room to deal with a medical issue and crisis that was totally unrelated to COVID. But we have that going on in the state. So why you believe the pandemic is over is beyond me. But that's just Chris Johnson's personal opinion, not a legal opinion. The best thing I can tell you now is contact your legislator. Tell your House of Representatives member and your state senator that virtual meetings were good. And again, in my local community, everything went virtual, and participation actually increased. We had more people come to the meetings than bundling up in the cold today and coming down to City Hall to tell you about what their issue was, if they could do it from the comfort of their study or their living room. And I guess I'm going to conclude with my first rule of public service, especially as it relates to the Open Meetings Act. It's not fun if you're sitting in jail. It just changes the whole scope of why you became a public official. You didn't do that to get caught in a mindless trap on the Open Meetings Act. So be careful out there. And we have a lot of OMA resource material for you. Again, I've listed them all for you. And I got to change that slide. It says Bill Schuette, but it's now Dana Nessel. So I do apologize for that error. Any questions? We went through like 3 hours worth of seminar in about 8 hours. So.
That was well done. Well done. Any questions, anybody? No? I like your quote.
Yep, I know it's something I don't want to be.
No, I agree. I think I've told my kids that before, but that's a good one. So,
I have a question. Has to do with something I do on a regular basis. I send out emails to a group of residents, and the group keeps getting larger because residents want to hear what's going on, so I give them information. And there has been times recently where I've given my opinion, and I've made it very clear. So if we have something going on in the community and it's, some residents like it, some don't, I've said, here's my opinion on it. I always thought, and I'm starting to wonder, listening to you, that all elected officials should give their opinions. If you don't, how do they know where you stand on something? And is that right or wrong now? I'm starting to wonder.
It's the way that you do it. If you give your opinion while you're here at a council meeting, you're fine, because you notice the meeting, it's public, the public can comment on it, your fellow council members can comment on it, no problem with that. The problem with electronic communication is, for example, I handled a case, or my law firm handled a case where a recreation commission had 4 members that wanted to do whatever it was. And they started sending each other emails. Let's do this at the meeting. Let's do that at the meeting. Let's do. 3 of them were actively participating. The 4th was just on the email and never commented. But the circuit court judge in that case threw out what they did because they hadn't followed the requirements of the Open Meetings Act. So if it's a one-way communication, you're always fine. You can communicate with that email to your fellow council members if you want. The problem is when you hit reply all. And we've been trained in business to hit reply all. It's almost second nature now. And that's where you start violating the Open Meetings Act. So if on your email blast you include other council members, the possibility of hitting reply all exists, and that's where you're going to be in trouble. Just sending an email blast out to a select group of citizens in the community, no, that's not deliberating. It's giving your opinion on something, but it's not deliberating. Do you understand that difference?
I think so.
Okay. Because that's where you run into problems. It's when there's the back and the forth, and I think this would be good. I think that would be good. I don't agree with you on this. I agree with you on that. That should be done at a public meeting.
Chris, would you also say that in Joe's situation, or I was thinking in social media, if the council person is putting it out there, make sure that you're saying, I'm speaking on my behalf. I'm not speaking for the council.
Right,
I'm
that's kind of what I
sharing
was-
my opinion. I'm not speaking for the city.
Exactly.
Yeah,
And that's
well,
why I was talking about the social media policy, where you say, this is Chris Johnson's opinion, this isn't city council,
Yeah.
or I'm going to vote this way at the next council meeting on this issue, or whatever you're doing. Also, though, the problem potentially with the social media is if your fellow council members start responding to that comment, that's where you might end up doing, again, electronic deliberation. So you're on your Facebook page and 3 of your other council members comment, guess what? You're going to be in real trouble real quick. So as a practical matter, you're almost safer not to use Facebook in that particular fashion. It's for circulating pictures of your kids and grandkids.
Yeah.
Very good. All right, that gives us about 10 minutes. Everybody good? Any other questions? Sounds
Thanks.
good. All right.
Thank you so much.
Thank you very much.
Thank you.
Thank you.
Appreciate it. Thanks for
I
your
have
time.
a sign-up sheet.
Oh, okay, we'll get everybody signed
Sign
in.
this because you do get credit for this
Oh.
meeting. Oh, you have? Okay, good.
Awesome.
Perfect.
Thank you.
All right, everybody. I will seek a motion to adjourn.
Motion to adjourn.
Second.
Motion and second to adjourn from our training workshop. All those in favor say aye.
All right.
Opposed, no. We're adjourned. Thanks, everybody. See you in a couple minutes.